Morning. We've got a little bit of morning left, but if everybody could reassemble, we're going to need to use our time up. We want to leave enough time for you guys to ask good questions at the end. I had said kind of jokingly when I was talking to this panel that it was kind of an embarrassment of riches of resources we have. But so far today, looking at everybody that's been up here, it really has been an embarrassment of riches. You've had access to some pretty good thought leaders in the field. So I'm joined today by Angie's okay? Angie Messer, who is Executive Vice President at Booz Allen, right? And Predictive Intelligence, is that Predictive Intelligence? And Bryan Rose, who is a Managing Director at Stroz Friedberg, and Jen Levine, who is a partner and co-chair of commercial litigation, is that right? With Pepper, who are our nice hosts today. So what we're going to do is we're going to talk about some of the things that you've heard today, but in a different kind of way. Not so much Q&A. They have a lot to cover, so we want to make sure we get it all in. People will join in and have conversations, but we really want people to give their presentations. We're kind of going to go step by step of what happens in a breach environment. First, we're going to talk about kind of preparedness and what to avoid, and then up through the first 24 hours after a breach is discovered, what you're going to do. And Angela's going to talk about that. And then we're going to talk about forensics, which is kind of the most important thing from kind of both angles of how you get to litigation and how you avoid litigation. So Bryan will be talking a little bit about what to do with your forensics investigation when you discover a breach. And then Jan is going to talk about the litigation side of things, kind of the causes of actions, the damages, the potential things that are out there. So hopefully you're going to hear from me the least of all, because I have the least amount to say. However, I may interrupt and ask a question if I see something going on, but please, at the end, feel free. We're going to have a substantial amount of time in asking questions, just like before. Betsy in the back there will come around with the microphone and fire away. So I'm going to turn it over to Angie.
Thank you, Don. And I want to say thank you to Bloomberg for hosting this event. It's been, I think, a great morning, and hopefully this panel will kind of bring to light what happens the first 24 hours and why is it so important. By way of background, I've had not just a technology and cyber background, but I also have a military. I had a decade of serving in the military, where I was able to look at intelligence, operations, and planning, and what it really takes to fight adversaries. Well, I've been able to apply that the last 19, 20 years in the corporate setting, in the federal government setting, and I think there's a lot of analogies to be made here in what those that are in the risk area, those that are in the product area, those that are in the privacy and data area, that we actually share a common theme here, and we have some common actions that we all have to take. So given that the environment's even more complex, cloud, mobile, social, networks aren't even networks anymore. And what does an organization do from a data breach perspective? And I think this morning was very helpful on the steps you can do beforehand. And I'm going to combine that with what do you do when it actually happens. So what is a common theme here, and what do you do in those first 24 hours? I think there's two words to describe it. It's speed and precision. So let me kind of explain what that means and what the context is. The first and most important thing when that known data breach happens, those first 24 hours, is to activate the incident response team and to actually exercise the cyber incident response plan. Now, if many of you are saying, well, our organization doesn't have that, well then that's already a problem, because you don't actually make the plan while you're actually trying to solve the problem. So who is the incident response team? Now, our analysis and our actually experience, and my own personal experience of a data breach, we've looked at hundreds of cases. We actually even war game it on a frequent basis. That incident response team is not just the CISO or the IT security. In fact, today's modern incident response team is actually C-suite, it's operational line managers, it's HR, it's clearly legal, it's privacy, it's public relations, and it's also probably outside third parties, which you're going to hear Bryan talk a little bit about too, that are part of the team when it comes to what you do the first 24 hours. And what does that team do? Besides exercising, and you've heard it in our other panels, you've got to have a plan. In fact, from a compliance standpoint, that plan needs to not only exist, it has to get exercised. It has to be assessed frequently. And when you heard in the first panel, what Mary talked about is different kinds of threats. The same exercise might be different for an insider, for ransomware, from a hacker, from sabotage. She identified those major threats, and I think you have to play out those scenarios in your action plan to make sure it stays relevant and up to date. And from a litigation standpoint, there should be some evidence that that action had been actually exercised. So what is this team? This team are problem solvers, because what kind of problems are we dealing with? We're dealing with intellectual capital problem, a customer problem, legal problems, obviously, policy, potentially lost revenue problems, communications and public relationships model problems, and branding, which for many industries, it's a trust problem. So it takes a village. It really takes a team effort to try to problem solve as each minute and each hour goes by in terms of discovery. So exercising that plan, what are the next steps that need to be done? In fact, Sharon mentioned this about establishing the privileged reporting and communications. That should be part of the plan of what's underprivileged and what's not. Using independent cybersecurity experts, having intelligence before the breach or having awareness sometimes now is an audit and traceable, so having a third party to assist with that or have your own organic. Having forensics experts, which again Bryan will talk about, is actually critical. Stop the bleeding, stop additional data loss. That is part of the first 24 hours. Clearly securing evidence and preserving computer logs and documenting the breach overall, because again, that's all traceable and submissible. And then knowing what your legal, your contractual, and your actual insurance notifications, like Bob had talked about before, what those requirements are. While we have the FTC standards, which I know that Jan's going to talk about, there are some industries that have other standards beyond NIST that are regulatory in nature, and you have to know what those are, again, depending on the threat. And then finally is making sure in your plan you know when to notify regulators and actually when to notify, and if you should, law enforcement. Because in this case, law enforcement can be your friend. So in sort of wrapping up, besides some blocking and tackling that needs to get done those first 24 hours, changing security access, changing passwords, and obviously ensuring that the encrypted data that you had a plan for is still valid, is two things I'd like to kind of close with about what you do, and that's about communications. One, in our war games, we've found and tested time and time again, internal communications is just as important as external communications. So you have to have a strategy and a plan and know who is going to execute that. Just as you need to know who is the, I'll call it incident response team lead, executive, commander, whatever analogy you'd like to make, but the governance process has to be in place and who does the communicating. But it's also this importance of external communications. Now, beyond the notifications, beyond the actual engagement with law enforcement, I think there's a social responsibility that we all have here, a contract on how we actually share information. And so I think we see emerging in this area, back to the theme of it takes a team, or better yet, it takes a village. We have to communicate across industry. We have to share IOCs. We have to be, if you are, for example, in the financial sector, you collaborate with the financial sector ISAC, and now each industry has their own ISAC for information sharing. And again, from a litigation perspective, making sure you are connected so you're receiving information is important, but also that you're sharing information now in your obligation to the community. And then I think finally this collaboration that I mentioned with law enforcement, it happens at the federal, the state, and the local level with federal agencies. Because quite frankly, to fight adversaries, it really does take a village, and it takes a collaboration environment in order to do it. And this, again, has to be in place and be activated in the first 24 hours.
Angie, let me ask you one thing, which is, you talked about stopping the bleeding, that's a priority. And then you also talked about working with the government. And I've heard at least a few government officials talk about, well, maybe you don't want to stop the bleeding until you alert us and get us involved, because we won't be able to tell what's really going on unless we can see what's happening. That's kind of a dissonant approach for a lot of the people I talk to in industry. What do you think about that?
And this is maybe a good segue when Bryan talks about the forensics. You have to dig underneath to know what, who, and why. And so part of the stop the bleeding is there's some initial ones that look apparent, but what you don't want to do is actually turn off everything where you give signals to the criminal activity that you actually have awareness. But it depends on what kind of problem it is you're trying to solve. And I think there's been some lessons learned that if you try turning off things, you actually could lose evidence. So it has to be from an investigation and an evidence perspective. And again, it takes what kind of breach are you talking about. So not black and white, but I think you have to do discovery, you have to do remediation, and it's a process that takes, I'll call it agile. It's very iterative as you go through those 24 hours, the next 48 hours, et cetera, depending on how long the penetration's actually been there.
Yeah, and it's important to hire Bryan to come in and do the forensics, yeah?
Yeah, I think that's a nice segue to what I was going to talk about from a forensic perspective, because one thing in listening to Angela that I was going to emphasize is that that first 24 hours is critical, and there are a couple things from a forensic perspective I always like our clients to think about immediately before you do anything. And the first is evidence preservation. And that's critical in these cases because electronic evidence is very fragile. So, for instance, if you unplug a machine and take it offline, you're going to wipe the memory essentially from that machine, which is a very fragile and very valuable piece of evidence from a forensic perspective in incident response cases. Frequently, attacker activity shows up in the memory, but not anywhere else. And so if you unplug that machine and we have to turn it back on, the memory is going to be gone and we're going to lose that. There are also other critical data sources that frequently get lost in instant response cases because preservation is not thought of very quickly. One is, if you continue to use machines that have been impacted by an attacker, every time you turn on a machine or use it to write a Word document or whatever you're doing on that machine, the processes in the background are overriding evidence on the disk space. And so that's a real danger with computers. And with servers, if they're impacted, those are overwritten fairly quickly. And so if those aren't imaged or taken out of rotation, you're going to lose evidence. Log data is frequently very critical in instant response cases. And log data usually is only retained for a set period of time. So it literally rolls off on a daily basis. And so every day you wait and you don't pull log data, you're going to lose critical information. And so I always encourage people to think about preservation right up front. Now, that doesn't always mean that preservation is your top priority, right? I mean, I think it is a difficult situation because you're balancing preserving data and investigating the incident against trying to get your business operations back up and running. And so we do have clients who face difficult decisions about, can I pull that system out, or do I need to leave it up for my business operations? When can we go in and image these computers? And to do so would really impact their business operations. And so you will have to make difficult decisions, but if you've activated your incident response team and you think about those questions, at least if preservation takes a backseat to some other priority, it's at least a reasoned, thoughtful decision, and the data's not lost simply because someone forgot to think about preservation. And the thing about failing to preserve, right, you can't undo that mistake. And from a litigation perspective, that can be really difficult in terms of justifying the reasonableness of your response. Once you don't preserve something, it's gone, and you can't unwind things and go back and preserve the data. So I think preservation is very important. The other thing, and Angela touched on this, and I think Don's question was aimed at this, is I think it's very important to consider before you do anything is how are we going to do this investigation? Because as soon as you start doing things like blocking IP addresses, which is a very common tactic, or changing passwords, you're going to alert the attackers to your presence. And that could be problematic for a couple of reasons. One, it gives the attackers time, if you haven't had the chance to preserve data, to go in and destroy the evidence of their activities. And so you may lose critical information because you've alerted the attacker, and in withdrawing from your network, they're going to destroy critical evidence on the way out. The other thing that's really critical is sometimes the best way to do one of these investigations, and this is very counterintuitive, I think, for people, but is to allow the attacker to continue to access your network so that you can watch them and figure out how they're getting into your network and what they're doing while they're there. Now, that's not always an acceptable way of investigating. I mean, sometimes depending on what they're accessing, you may have to cut that off immediately. But that's another thing I encourage people to think about right away before you get in a situation where you've called in your forensic vendor. And this happens to us all the time. They come in and say, okay, we had 3 impacted servers, we've unplugged them, we put them in the corner, we blocked all the IP addresses. At that point, we may never find out what happened because before anybody even thought about the preservation and how are we going to do the investigation, the knee-jerk reaction is sort of to get the people out of your network, and it's not only destroyed evidence, but it's precluded our ability to investigate by watching their activity. And so those are hard questions to answer. I think it's great now that on a lot of incident response teams, you do have C-level executives who are there because
Exactly.
those are high-level decisions that need to be made, balancing out, how you're going to get the attacker out, what your business operations are, what your future litigation strategy is, and you need all those decision makers in the room to make those decisions quickly and efficiently so that you can proceed in a reasonable manner.
And Brad, if I can add, I think that's where the tension lies, is CEOs want to stop the bleeding. They want to make sure that they're going to sometimes they're notified by law enforcement that there actually is a breach before the CISO even knows there's a breach. And I think this tension between the business side, the forensic side, it has to be a dialogue real time because there's not a complete playbook. You have to actually live the moment and problem solve while you're doing it.
That's true, and it can be even more complicated than that because it's not only the business people versus the technical people, the IT folks, but you may have a split in IT between the CIO who wants to get business up and running, and that's his job, and the CISO, who's a security officer, who needs to make sure he can figure out what happened and that he can make sure his network's secure. And you'll have those people in the room who disagree, and the business people have a different perspective. So you need to have the right people in the room. The general counsel may have a completely different perspective, outside counsel. And
Well, Bryan, that group of people you're talking about, is that the village that we use? It sounds like an expanded village. There's more people in the room. There's a lot of people yelling at each other. That doesn't sound like a real efficient thing. So how do you deal with the potential conflict? Do you put somebody in charge who's there the final say?
I think there has to be a decision maker ultimately.
The answer is yes.
Yes, and it's usually somebody at the C level. I mean, the C-suite used to not get involved in these things, but I think now they're usually involved, and they're usually the decision makers who drive these decisions in the midst of competing concerns. The other thing I would just mention is I think one of the things you can do is actually, once you have an incident response plan in place, you can do tabletop exercises, which sort of put all these people in the room and have them sort through these issues in the context of an exercise, so you can surface what these various issues are, what the competing concerns are, and just make sure that you've got all the right decision makers in the room and that things are moving smoothly and that you've got the right decision tree.
And in fact, I think the best practices say is that's practiced at least quarterly. And so you have to exercise it, and you can't decide who's in charge the time that that breach occurs. You have to know who's going to be in charge.
One thing I want to say from a litigation perspective, this is way before the complaint, but just listening to this discussion is, from a litigation perspective, that is why it is so important to have a plan of how you're going to do. If your plan says, we shouldn't unplug the machine because we want to do forensics, that is thought out beforehand. You have a policy that you can defend. Because remember, in litigation, what hurts people all the time are emails. And if you do not have a plan, you can imagine the emails that are going back and forth. Should we unplug it? Should we not? But people could get hurt. But you know what? I don't care if people get hurt because we really have to find the investigation. Those emails will kill you in litigation, really. And it not only hurts liability, but it will triple your costs. Because what happens is that if you have emails going back because you don't have a plan, then in discovery, all of the emails get downloaded, and people like me and my team have got to read them all because you have to decide which ones are privileged, which ones are relevant, which ones are not relevant. So when you're in a crisis, it is really good to have a plan, particularly in this environment, because all of you are shaking your heads. You can imagine those emails, and if you have an email that says, even though it was a thoughtful email, that it is better to preserve, even though there may be some additional compromise, that could be a very devastating email for your litigation.
So, I mean, we're back to forensics again. So I would really like to know kind of does Stroz get involved in the wargaming side of things too? I mean, do you guys, when you talk about forensics, there's forensics after the fact, and then there's this kind of ahead of the curve, knowing what you know, because you do forensics, people need to do in advance, the stuff Angie was talking about. So do you guys do that kind of thing? Do you help people wargame?
We do. We do wargaming. We do incident response readiness programs. I mean, I think frequently it's helpful to sit down with your outside vendors. For instance, I think the best relationships are with our clients where we actually are sort of pre-positioned to respond in cases. Your IT team knows your forensic team. You've thought out things like what kind of scanning capabilities and what kind of forensic capabilities does the company have? How are those going to be supplemented, even down to the minutia of if we have to put a scanning utility in, where are we going to put in your network? What port are we going to plug into in your data center? Having all that laid out in advance can make everything move much more smoothly because, for instance, if you come in and say you do think about preservation first, right, and you say, okay, it's critical that we preserve this data before we block IP addresses. If it takes 2 days to position things to preserve the data, that's 2 days you've lost, right? If you can get in right away and preserve in a course of 12 hours, then that may make that solution more palatable than if you have to wait 2 days. And so having as much of this sort of mapped out in advance and wargaming it so that you understand how it's going to work in practice is really critical because these are the kind of situations where the difference between something taking 48 hours and something taking 24 hours is really critical.
The only thing I'd add to that, and Brian's absolutely right, I could foot stomp it, is you have to have these relationships ahead of time, not when the breach happens. But I think there's something to be said about wargaming, continuous monitoring, that it's not about when the breach happens when you bring a forensics team in. Advance, APT hunt is very important that you know what that is, you've got your vendor, you've got that trusted relationship. And I think our other panels talked about that because now you've also created another partner who actually knows exactly what's going on in your network. So I think those relationships are absolutely critical for the full life cycle.
Okay, Jan, so assuming that they do everything right and nevertheless everybody's vulnerable and there ends up being something that somebody's going to sue you about. So let's talk a little bit about what people should be thinking about in a general way about cybersecurity and litigation.
Even though I practice in this area, I am really not too technological. So I have the green on, I think, yes. It's interesting in this area, the lawsuit and the people come in so quickly. I mean, normally in other areas, people might not sue for a year or two. I mean, you always think about the statute of limitations. It is much more immediate in this area because a breach notice goes out. You say to the world, guess what? We may have compromised you 10 million, 30 million. You see it all of the time. It's a very unusual situation where you are required by law to advertise that a whole group of people may be injured. And that is why it moves so quickly and why I think your litigators need to work with the response team because all of these decisions that have been discussed will become part of the litigation. So what usually happens after a breach, there's really 3 entities that will sue you or take enforcement actions. One is the FTC, and I think the first panel talked about that. And on those, just so you know, you can download them. This is what Start with Security guidelines look like. You know, the first panel. You can actually download these. You can read them, and they have the different enforcement actions and you can get an idea from this what those complaints look like. And on the FTC website, you can see the complaints, and then you can also see the consent decrees that show you what you have to do when you settle with the FTC, and it's really not very pleasant. I have to tell you, most of them go on for 20 years. They're very expensive. So when you go on the FTC website, you can take a look at them. So you have the FTC, and then you have to remember you have your state attorney generals. And the state attorney generals need to respond to their constituents. So when there is a breach, and 50 million of their constituents get a breach notice and it hits the paper, guess who gets the call? The Attorney General's office. So the last thing you want to do is keep the Attorney General without knowledge. You want, the minute you know that there is a breach, or even before, if there are any issues, you need to make friends with your Attorney General. You need to, this is not an area where you say, don't let the government in. There is going to be a breach. It is much better to have talked to the Attorney General before the notice goes out. Because if the Attorney General reads the notice, that's how they get notice of your breach, that already sets up a difficult dynamic, a dynamic where there may not be trust. And so if you have a breach, we always recommend reach out to the Attorney General, bring them into the process, explain to them what happened, explain how you've taken control, explain that you have policies and procedures, bring them in. It also lets you tell your story before your breach notice goes out to the Attorney General. You take ownership, and you can sort of frame the issues the way you want to before they're getting inundated with calls, because then they're under a lot of pressure to make sure you are doing things right. So in our opinion, you really should talk to them often and early. The third, of course, is the private lawsuits, and they come in different shapes and sizes. One, you can just get an individual lawsuit. You usually don't get an individual lawsuit unless you're in the healthcare environment, sort of the hospital environment, because any individual claim itself is probably not worth that much money. It's when there's a big class action that it becomes much more lucrative. So you usually are hit with class actions, and they are from consumers, the people whose information may have been compromised, from your own employees, from financial institutions, and those are very serious suits. I think you see it in the Target case. The consumer class was settled, but the financial institution case is going forward, and actually class was just certified. So the financial institutions, when you think of really who takes a hit in these cases, a lot of times it's the banks, it's the financial institutions that have to give all the consumers new credit cards. They take the hit often for the fraudulent payment. Usually the consumer doesn't pay. It's the banks and the credit cards. Also, the banks and the credit card companies, the financial institutions, when there is a big breach, often have to hire new employees just to keep on top of the telephone calls. So they can quantify their injuries, and their injuries are really usually more than the individual consumers. So those are cases to really pay attention to. Then there are the stock drop cases, the securities cases, and then the derivative actions. So those are the lawsuits that are really facing everybody. So what is the first way to attack these? In these cases, actually, Article 3 standing. And are people familiar with Article 3 standing in this environment? Because that is the name of the game on the first level of defense. Yes? Raise hands if people understand standing. If not, I will give an overview. I'll give an overview. Yeah. Okay. So standing, Article 3 standing is you're not allowed to go into a court unless you have a real case or controversy. You don't just walk into a court and say, really, I'd like to talk to you about an issue. You have to have a case or controversy, and that is really what standing is. And standing really is a three-step process. The first is there injury in fact? Have you been injured? Second is is your injury traceable to what you're complaining about? So here, is your injury traceable to the breach that you're going to sue over, or is it traceable somewhere else? And then third, can the courts actually give redress for it? I mean, is there a remedy? So those are the three levels of standing, and really the cases are mostly focusing on that injury in fact. There was a Supreme Court case called the Clapper case that came down in 2013 that really changed the law of the land. And injury in fact was defined as a concrete, particularized, actual or imminent injury. It can't be speculative. It can't have, well, if this happens and if that happens, then I would be injured. It really has to be concrete. So when you think about the injury in a data breach case, just because your data has been breached does not mean that you are injured in a concrete way. It does not necessarily mean that your identity has been stolen. It does not necessarily mean that someone's going to fraudulently use your credit card or do some other monetary damage. It could, but it doesn't necessarily mean that. What happens in this environment is that there's a breach, everyone gets hysterical, and they sue, and the courts generally, although there are exceptions I'm going to talk about, generally the majority of courts have held, absent actual identity theft or other identifiable fraud, mere increase of risk of harm is not sufficient for injury in fact. So, in most of these cases, the defendants, the companies, will file a motion to dismiss saying the injury is speculative. In the complaint, no one has said my identity has been taken or there's a fraudulent credit card or something. But they usually argue that there's an increased risk, an increased fear, and then I have to take all of these things. I have to get monitoring, I have to do this, that, and the other thing, and that costs money. The courts are generally saying that is not good enough. However, plaintiffs are getting smarter now, and they actually are pleading better and pleading an injury. In the Third Circuit, it is still very clear that you have to have actual misuse of data. But there's always the Ninth Circuit and those California cases that are sort of changing the landscape. So there are a couple of cases in the Ninth Circuit, the Adobe case, the Starbucks case, and some others that have really started to open the door. And they are really looking at what is the increased risk. If the increased risk really is imminent, in the Adobe case, the hackers came in. There was no actual injury, but the hackers came in. They actually went around and they found, and the data was encrypted, but the hackers figured out how to unencrypt. And they got in, and the court really said, wait a minute, that increased risk is really imminent. Those hackers are really looking, and so we're going to allow standing. So standing is getting open. There was a recent case in the Seventh Circuit, the Neiman Marcus case, that has allowed standing. Really, credit card information was taken, not Social Security numbers, not birthday, credit card information. But Neiman Marcus reimbursed everybody. And so one could argue there's no standing. But the court disagreed, and the court said because of what was taken, there really is an increased risk of future fraudulent charges and a greater susceptibility to identity theft, so there is standing. So standing is an issue that is a very hot topic. You got to read the cases. You got to really look at what is going on and actually your forensics. So
Jan, let me ask you something. You know, standing is such a, like you said, it's the first line of defense. What if that first line of defense gets breached? We're doing more military analogies today. And, you know, and it sounds like to me, at least from an observational standpoint, that that's when settlements happen.
Yes and no. If you get by, there can be settlements, but the courts are now developing. Now, most of these cases are still in the motion to dismiss stage. We haven't gotten far enough for summary judgment, but there are other causes. So once you open the door and you have the lawsuit, you're allowed to go forward. There are a lot of now really interesting issues about causes of action. And the real question is, are these negligence causes of actions, tort causes of actions? Negligence, fraud, misrep, or are these really breach of contract cases? So we are now seeing a great defense called the economic loss doctrine. And the economic loss doctrine basically says if your loss is economic, if it is not a personal injury or property damage, you're really talking about financial loss. That is a complete defense to all negligence claims, all. And they get thrown out, and courts have thrown out negligence, misrepresentation based on the economic loss doctrine. And then you're down to a contract case. And then courts differ on contracts. There are some employment cases that go both ways. Some courts say there is no contract between an employee and an employer about security. The employees that are suing are saying, wait a minute, as part of my job, you asked me for, my personal information, and you implicitly, impliedly agreed to use good security processes. Many courts have said no, an employer did not make that contract. That was not a contract. A court recently in the Eastern District of Pennsylvania said there was an implied contract. That is sort of a shocking concept, that an employee would actually have an employed contract with their employer. It's the Coca-Cola case that's actually in your material. So that's a fascinating development. And then there is a whole host of sort of these unjust enrichment, restitution kind of claims, which as a lawyer academically, I actually think they're becoming a catch-all when courts might throw something out, but you got through standing and you want to have some cause of action. So I think it's becoming, honestly, a little bit of a hodgepodge. A unjust enrichment case should not academically go forward if you have a breach of contract case, because an unjust enrichment case says that there was a benefit bestowed on the other party, and that substitutes for consideration. But if you already have a contract, there is consideration. So you really shouldn't have an unjust enrichment claim with a contract.
So Jan, it seems to me that it's very evident why lawyers might want to be in the room for your village with all of this coming up. So we're running out of time, and we wanted to leave time for questions. And you just let us know, and they will bring a microphone to you.
This question's probably mostly directed to Bryan. We're talking about the importance of forensics. So a lot of companies now that are getting started are building their companies in a different way. A lot of them will have, a back end with a company like Amazon, and if they're doing payment processing, they'll work with a payment gateway. And so often I see companies think that they don't have any security issues. And so I wonder, when you see breaches that affect, an e-commerce website, what are you seeing, and what are you seeing as far as what they should be doing to preserve data in their incident response, since it's a little different than, you've got the entire IT infrastructure within the organization?
Yeah, I mean, that presents difficult problems for forensics, and I think, and you'll see this a lot with organizations where they have a lot of their data in the cloud, for instance, with other third-party providers, or they rely on other groups to process credit card data, and so they don't themselves, within their corporate IT network, hold a tremendous amount of data. That, I think, creates real difficulties from both securing the data, right, because you're relying on third parties, and you don't always know exactly how they're securing your data. So I think it's very important when you're relying on third parties to make sure that they're securing the data in the same way you would, and I think that's largely handled contractually, but also by making sure that you've inspected their data centers, that you know how they're handling the data, and that you've verified it. You know, we see a lot of breaches where the breach is not in the company, not within the company, but it's at another vendor. Those vendors, especially if they connect to your network, also present a real problem because attackers can take up residence in their network, sort of move in and out of your network without allowing you a real opportunity to investigate it. So they pop up and then they leave, and you don't know what's going on because you're only seeing sort of a drive-by, and where they're really resident is in the other network. So I think you really have to control who connects to your network. You have to really control other vendors who have access to confidential data for your customers. And you also, I think, have to control the ability to forensically investigate that. So one of the real problems can be if you're relying on a vendor and they get breached, what rights do you have to go in and do a forensic investigation of their network, right? I mean, it's your customer data, and your customers are going to hold you responsible for that. You're the one they're going to blame. They don't care who held the data. But frequently, you're in a situation where you can't actually get access to the network to investigate because you haven't thought about that in advance. So thinking about the ability to investigate how other people are securing your data, all those are key questions you really have to try to control.
And another suggestion I think that I'd make is, quite frankly, what we help clients with is you have to relook your security architecture. You're the one accountable for it, and you have to decide, your current infrastructure, how is that secured? The hybrid infrastructure that you're migrating to in the cloud, you have to know that. And by the way, there are solutions out there, but I think that responsibility does rest with the CISO and the CIO. So you have to look at the MDM strategy. That's a critical part of it. So all these things are a factor, and I think what CIOs and CISOs have to do now is they have to refresh that security architecture. And I think that's paramount because the data strategy is part of it, each layer, the infrastructure layer, the platform layer, the software as a service layer, the application, all those are factors now. And I think that's what we're trying to help clients, is you need a holistic picture on that architecture.
We before this started, said each of us could probably get up here and talk for a couple hours, and we're in danger of doing that. So are there any other questions? Let somebody else have a chance.
I have what might be a more difficult question, but I'm wondering, as you're building this team, where does the legal department and outside counsel lie in terms of, you know, helping manage that risk, and where should they be in that process all along?
I'll just talk from my personal experience in our own internal practice, and then what we do to support clients is they are part of my team. They are there from the get-go. I think each of the panels have said, your strategic partner internally is your legal team. And in fact, for the practice that I lead around future cyber issues, cyber technologies, the wargaming, and this predictive intelligence, the legal team is there with us in how we develop product. So they're a key advisor. In fact, our legal department actually has, you'll hear a lot from the Pepper Hamilton Group, they have a lot of technical expertise that they bring to the table. These aren't just, certain experts in their field. They're experts in law, privacy, data, as well as technology. And from our dialogue, they stay very relevant to what's happening in SaaS, mobile, social, cloud. They're a key part of a team right from the beginning.
I think also in a law, when you work with your lawyers, so you heard from Sharon Klein this morning, she would be on the front end way before the breach, policies and procedures looking at it. Lawyers are always involved at the point where there is a breach. But before the breach notice goes out, you would bring in your litigators, at least in my opinion, to look at that breach notice, both from regulatory, and then the breach notice is the exhibit, to the complaint. So usually a team of lawyers all throughout
It takes a
talk
village
to each other.
amongst
Yeah.
the lawyers. I would agree there's not one kind of lawyer. And the SLAs, I think, are very critical. All of our lawyers review our SLAs that might hold us accountable for providing services.
Okay, there's a couple record-keeping things I need you to keep in mind. One is that there's an evaluation form here somewhere that if you could fill out, my corporate managers would be happy. And over here is the CLE sign-in thing, so if you're hoping to do that, please sign in. So I want to thank Angie and Bryan and Jan for this panel and give them a round of applause.
Thank you, Don.
Finally, I want to thank our host, Pepper, and then I kind of get to pat myself on the back, and Bloomberg B&A for doing this, and then for Bloomberg for letting us use this nice space. Thanks for coming.
Just want to, on behalf of Pepper, we really appreciate you coming. We really appreciate Bloomberg. And I don't know if everyone has these handouts, but we write client alerts all of the time in pieces, and they are short. They're not long law review. You can read them quickly. They have a lot of the cases we talked about. Anyone that wants to be on our mailing list, we have a privacy mailing list and a litigation mailing list. You can keep up to date. We would love to work with you in the future, so give us a call. Thank you.